Honorable Cebekhulu.
Thank you, Deputy Speaker. The Watershed Native Land Act was promulgated on 19 June 1913, and on its centenary, the IFP goes down memory lane to take stock of its devastating effects in an effort to map out the way forward. While we acknowledge the unspeakable effects of this act on our sisters and brothers who lost all private title to their land ownership in the urban and peri-urban areas, in this presentation, the IFP would like to focus on communal lands which were wrested from our traditional leaders, particularly African kings and Amakosi, who held this land in trust for their clans. This countrywide dispossession happened long before 1913 and continued thereafter. It must also be put on record that the pre-1913 land dispossession were characterized by a lot of stress, violence, and bloodletting. It is for this reason that the IFP fully welcomes pronouncement by the government that in the second window of opportunity, which is about to open, pre-1913 claims of land restitution will also be considered. Indeed, it was the claims of communal land which received less consideration in first period, which ended on 31st December 1998. Whilst the IFP is appreciative of the second opportunity to claim restitution of the land of our forefathers, it is hoping that this process will not be marked by frustration, procrastination, which characterized the previous process. The manner in which government officials in the Land Claims Office handled many applications left a lot to be desired. To avoid the repeat of the frustration which were experienced in the first period before, to avoid the, Chairperson, to avoid the challenge that we had before, the IFP, whilst is appreciative of the opportunity, would like to point out that the officials which are employed by the Land Claims Office, there was a simple no permanency on and no continuity. In many instances, when claimants visited the offices to do follow-ups on their claims, they met with new faces which required them to repeat their stories, since the new incumbent knew very little or nothing which had gone on before he or she assumed office. Very often, the files could not be traced, and this led to a very slow progress, with the result that even today, some of the applications lodged before 1998 have not been finalized. This literally killed enthusiasm in the process. Related to the above statement, in this is this government procedure which dictates that when the land which was claimed by people under Amakosi is restored, the community to whom it is restored are required to form CPAs or trust to administer such lands. The IFP views this in a very serious light. It can lead to endless conflicts. This simply means that an administrative structure is imposed on a traditional authority to undermine such traditional authority. In KZN, for instance, the IFP proposes that such land should be restored to Ingonyama Trust, which holds all Amakosi land in trust for communal communities. This is a kind of divide and rule policy which should never be allowed in the new South Africa if the government is serious about upholding the institution of traditional law and administration, which is entrenched in our Constitution.
Thank you.
In conclusion,
your time is up,
thank you.